Hello viewers, welcome to YouTube channel Lex Consilium Foundation. I am Major General Neelendra Kumar in conversation today with Professor BT Kaul, formerly of Delhi University. He has appeared before our channel a number of times. He had taught interpretation of statutes, labor law, constitution, and many other subjects during his 34 years long association with Delhi University. Prior to that, he had taught at Himachal University, and he himself holds a doctorate. He'd done research in Delhi University, followed by his teaching, his scholarly association with Australia and London. Professor Kaul, welcome. और आज
Sir,
आपसे सवाल होगा
always pleasure to be in your program.
जी। तो आज आपसे बातचीत होगी पिछले हफ्ते और थोड़ा पहले। सबको मालूम है कि सुप्रीम कोर्ट के सामने ये मामला आया जो सो मोटू सुप्रीम कोर्ट चीफ जस्टिस सूर्यकांत जी ने इसकी नोटिस ली थी और ये ताल्लुक रख रहा था एनसीईआरटी की नई टेक्स्ट बुक क्लास 8th के लिए जो कि न्यू एजुकेशन पॉलिसी में है। और इस किताब का जो एक चैप्टर था वो ताल्लुक रखता था रोल ऑफ जुडिशरी इन अवर सोसाइटी, और वहां पर एनसीईआरटी की ये किताब इशू की हुई। उसमें दो चीजों पर कुछ लोगों को आपत्ति हुई। दे ऑब्जेक्टेड टू a remark that people do experience at various levels of the judiciary, and secondly, it called for taking swift and decisive action against instances of corruption where they may arise. This was not to the liking of some people. After this matter was flagged by the Indian Express, Supreme Court took suo motu notice, and the headline the next day in the papers was that the Chief Justice said that he would not let anyone defame the institution, commenting about the NCERT books. Now, the council, in this case, Board for Secondary Education, CBSC, they expressed regrets. They said that the books are being pulled out of the shelves. In fact, they went to the extent of retrieving all the books that had been sold, and it is no more on their as part of their e-repository. Now, amongst the serving and more so the former judges, their reaction to this have been varied. On one side, we have say Justice N.V. Ramana, who said that he decried this textbook. He was not in favor of this. And Justice Ramana also said that can we have the students with the impressionable minds being taught about something based on corridor gossip and the basis of on which NCERT has tried to defame the institution and demoralize judges. Now, this was one reaction, and there were also other judges, former judges, who hold a view to the contrary. As opposed to this, Justice B.R. Gavai, the former Chief Justice of India, he is believed to have said, in the wake of the seizure of the high amount of cash from the official residence of Justice Yashwant Verma, the instances of corruption adversely impact public faith in the judicial system. Also, the newspapers carried remarks by one of the earlier Chief Justices of India, Justice S.P. Bharucha, who is learned to have said more than 80% of the judges are honest and incorruptible, but it is that smaller percentage that brings the entire judiciary into disrepute. It is requisite that corrupt judges should be investigated and dismissed from service. Now, when the attention, this view of Justice S.P. Bharucha was brought out, then Justice N.V. Ramana, former Chief Justice, is said to have said a loose comment by a former CGI cannot become the basis to do something or to teach this as gossip to the students. And also, there is an article by the well-known advocate Mr. Prashant Bhushan of the Supreme Court, who appears frequently for public causes, public interest litigations, and he pointed out that judicial corruption may manifest in many forms other than financial corruption, which include abuse of discretion, nepotism, conflict of interest, misuse of authority. Now, with this background, I would request
Prof Kaul.
कि आपका इस पूरे मामले के बारे में क्या नजरिया है? How do you view this? Prefer.
You see, NCERT is an autonomous organization set up by the government of India, and it has a very important task, and it is expected to advise central government and state governments on policies and programs for qualitative improvement of the school education. Now, it holds a very important position, and all of us know that we have grown with this name from the very childhood. The books, textbooks, and they're supposed to be very authoritative and of great impression to the young minds. And therefore, whenever we write something in this textbook which will go to the impressionable minds, we must be cautious that whatever we are saying, we make a distinction between institutional corruption and individual corruption. I cannot say that there may not be allegations of individual corruptions, but to malign an organization like judiciary, which I personally feel, because I have been a great ardent admirer of Indian judiciary,
you were the
because my
director of Delhi Judicial
was
Academy.
chairman of Delhi Judicial Academy, and also my Ph.D. Was on judicial activism on industrial relations in India, where I have demonstrated how Indian judiciary has, in absence of a statutory law, built up a body of the regulations, rules, principles, which have guided the industrial adjudicators in this country. And we had a robust industrial relations law in India before the new economic policy was brought in. Now, new economic policy, again, you see, there are judges and judges. Some judges are activist judges, some people are status quo judges, some people get influenced by the new socio-economic policies. So therefore, by and large, if I see, Indian judiciary has also been said to be, especially the constitutional courts, especially our Supreme Court, has been said to be a court which has exercised wide powers. Perhaps the most strongest court in the world. That is the kind of comments that have come from not underdeveloped countries. It is the judiciary from the developed countries who came to India, and also whenever judges went there, these were the comments that were made, that a progressive judiciary that India has, and we cannot, because of some aberrations, malign the whole institution. And especially when we have these books going to the impressionable minds. What will a student who is told? You see, there are three facets of this book, which I would like you to kindly consider. One, it says insurmountable areas is a fact of the matter. Now, insurmountable areas we know because we have 5.4 crore cases pending in Indian courts, which is what we call as in the grid, which is now displayed by even Supreme Court website. And we have at the moment about 92,053 cases pending before the Supreme Court. So the fact is that we have insurmountable areas. That is a fact of the matter. We have deficit infrastructure. You don't have to go by the courts in Delhi. You don't have to go by the courts perhaps in Chandigarh or cosmopolitan cities. But if you go to the courts in other states, the infrastructure is very deficient. You go to Bihar, you go to UP, and bigger states, you find that, yes, this fact is also fortified by the, statistics. But on the question of whether there is corruption at every level of the judiciary is something which has not been subject matter of any research, or there is no finding, there is no research on this point. So therefore, it is a very, very dangerous statement that has been made without there being any material to support it. I don't say that there may not be individual cases. We all know we are living in a world where we have social media, where we have IT, we have cases being blown up, where cases actually being brought to the notice of the people. But I think it's our endeavor should be that whenever younger minds are given some material to read, and especially NCERT provides some material to the younger minds, I think we need certainly to be very cautious in providing that material. Therefore, I think prima facie, this is a very strong statement made by the NCERT in its book. Therefore, has created a lot of reactions in the judiciary. It has created a lot of reactions in the bar. But then there are people who have their own opinions about how things are happening in the judiciary. But I personally feel that to show the whole judicial system in this kind of a light it's not desirable. It is not good.
You have indicated your mind,
Professor Kaul.
I would like to read out, say, from this article by Prashant Bhushan, and then I'll go on to. Now, Prashant Bhushan has said that though several challenges face the judiciary, including access to justice, the nature and quality of judicial appointments, and the independence of judiciary, there is little doubt that corruption is among them. This is not to say that corruption in other institutions of the state is a less serious challenge. There is undoubtedly corruption in the executive branch, given that corruption in the judiciary also remains a grave and deep-rooted problem, and one that is widely recognized by the public. So here there's a mention about public perception. I would also like to mention about a reported decision of 2010 in a matter by Justice Markandeya Katju and Justice Gyan Sudha Mishra. That's in para 16 of the matter that was titled Raza Khan versus UP Central Waqf Board of November 2010. And I read, of course, it's a selected excerpt. I can't read the whole entire judgment. It was written that some judges have their kith and kin practicing in the same court, and within a few years of starting practice, the sons or relations of the judges become a multi-millionaires, have huge luxurious cars, huge houses, and they are enjoying a luxurious life. Apart from this judgment, I read what Justice S.P. Bharucha had said, and lately Justice B.R. Gawai has said. Now, there is very little doubt that even if one instance has happened, say of Justice Jaswant Verma, we are aware that till today no action has been taken and a person was transferred from Delhi to Allahabad, from which he had come. Light of that, just because no research has been done to bring out the exact number of cases, do you still feel, number one, that this is not a reality? And number two, irrespective of that, it should not be talked about to the students?
I think what has come from your observations and your reliance on the judgment of Justice Karju and also Prashant Bhushanji, I think we still must understand there are people who have had this kind of these allegations have been coming. So what is important is that we must have a system which is very robust system. Now this is one of the drawbacks, because you can remove a judge only when you follow the procedure that is prescribed in the constitution. It is almost impossible to remove a judge. That is the whole purpose, is because judges need to be protected. Their independence has to be protected. But then the mechanism that is provided for, even suppose you talk about the in-house inquiry that is being held. Now, what is the legal status of that in-house inquiry? Now, we must therefore, I think 2-3 things are very important. One, transparency in the appointment of the judges. Second, accountability. Third, some mechanism. I think we need to bring some mechanism in the constitution itself where we can deal with erring judges. Allegedly, those who are said to have indulged in some kind of a corruption. As you said, why should a person, his son, be practicing in the same court? At least we have the policy of transferring. They should opt for transferring to outside the state, that state. Now you say that person, his son, he has a right to practice the profession of his choice. He may not appear in the court of his father, but he may appear in other courts. This is where I think they have to evolve some principles. That's why I say transparency, accountability. Now, this is a mechanism that has to be evolved. But I still feel that we have very good judges also. We cannot, you see, you can't project every judiciary as such as corrupt. You are that way creating a situation while people will not like to come to the benches, and people have started not coming to the benches. It's a great disservice to the society if good people do not come and become the judges, because we need very good judges as we need good lawyers. We need good judges, but make a system which is a very transparent system, and then bring in the accountability of the judges. That is a way forward. Otherwise, to
Now,
paint everybody. Pardon?
difficulty, Kaul Saab, is that as of now, it's common belief that we have a system where the judges appoint judges, right? So the appointment is being done by the judges by the collegium, except for the cases where the government may not agree. Now,
I
I
think
would also like to draw your attention
government
to
still has the power to bring in a law. I think on most of the bad thing that happened in the NJAC case, where the Supreme Court had an opportunity to make a suggestion to the Parliament that these provisions need to be recast. After that provision is recast, uphold that mechanism of appointing NJAC. I think that is a thinking which still must come in. We need to bring in, that's what I said, transparency in the appointment of the judges. We need to have a mechanism independent of appointment by the judiciary of the judiciary. That is a mechanism which must come in. Independent body must overlook appointment of judges. Now, what is happening is in the process, some appointments are recommended, government is not making the appointments. Some recommendations are coming, and the government is very quick in making those recommendations as appointments. Now, this is a matter which needs to be re-examined. But now let me give you an example. Why is there clogging? One of the biggest litigants in the courts, I am not only been a law teacher, I have not been only a judicial educator, I am also a lawyer. I am a practicing lawyer. What is happening is, at the drop of the hat, government goes in appeal, government goes in reviews, even the most weakest case. Now, there's a vested interest in the system. Lawyers make huge money because government is the biggest litigant in this country. So, frivolous cases, a mechanism, you develop a mechanism. What are the cases that should go in appeal, and those government, nobody is raising a question about the government's method of dealing with the appeals, government's method of dealing with the suits, writs. Those are matters which need to be looked. You can stop the clogging of the arteries of the courts if you're able to find filtration at some place where courts are not clogged. Every case is not fought in an appeal or a review or a writ. All those things are very important. Administration must take decisions which are reasoned. Administration must take decisions which are objective decisions. And not every case should go before the court. Now, these are matters which need to be looked at. And therefore, to blame only the judges and not to bring in the role of the government in promoting litigation in this country, I think that's not a good part of it.
I would want that in this discussion, we remain confined within the limited time to the topic that relates to here the corruption. Now, the bigger question is that this controversy, does it impact constitutional morality and judicial probity? You see, the large number of improvements may be needed. Well, we do not have time to talk of that. There is no dispute that the government is the biggest litigant in the country. But after all, we have a judiciary. The Supreme Court is functional, so is the High Court and the subordinate or the district judiciary. The moot question is that the constitutional morality and judicial probity, do they impact the quality of justice? That is number one. And in light of, again, I'm quoting from this article, it is said that in 2020, the then Attorney General, Mr. K.K. Venugopal, in a hearing before the Supreme Court, had stated that he had names of 9 judges of the Supreme Court saying that there is corruption in the higher judiciary, and 7 of them said so immediately after their retirement. Now, this is something which cannot be ignored. Well, one can say that why didn't they speak out while they were in office? We'll not get in.
I agree with you that there are murmurs.
Ji,
I agree with you that there are statements which have come from very responsible people, like you talked about Justice Barocha, you
ji,
talked about Mr. Venugopal, you
ji,
talked about Justice Gawai.
ji,
Now, if you read Justice Gawai's observations, which he made, he also said that we have the mechanism to deal with it. Only question is that you must have the courage to deal with it. Where we are faltering is on the question of putting the house in order.
ji,
And if we take a strong stand that we have to put the house in order. Now, like suppose, let us take the case Mr. Verma. Now, he is still a case, is an alleged case of, corruption. At least our Chief Justice at that time had to put it on the website. Now, that itself is criticized because there is no evidence now to substantiate what has come on the website. We should have at that time preserved the place, occurrence of the crime. And if you have not been able to protect the occurrence of the place of the occurrence of crime, what has happened is subsequently, how are you going to prove that? So that those are issues which are important. Therefore, we must have a robust mechanism of ensuring that probity. We have constitutional morality which has to be followed by all of us, at least judges who are sitting in the benches. It is very important that we must give effect to that mechanism of bringing people to book. How do we bring those people to book? Do you have the strength to do it? And that is very important.
Therefore, given that this situation has come up and we stand where we are today, what is the way out?
I think all of us need to examine how we can bring in that transparency and how can bring in that accountability, and the judges themselves have to introspect. Like, Justice Bunyan said that, he said, we must introspect, and that introspection is very important because what is at stake is the reputation of this great institution. What will happen over the period of time if this institution loses legitimacy? Let me give you an example. When ADM Jabalpur was decided by the Supreme Court, nobody said the judges were corrupt in the sense of what we talk about today. But judges lost their legitimacy. Supreme Court lost its legitimacy. And Supreme Court tried to regain its legitimacy by resorting to what they call as public interest litigation. It became the court of the poor, vulnerable, downtrodden, and environmental law jurisprudence by liberalizing the rule of locus standi. So Supreme Court again became a robust case, like you have Maneka Gandhi judgment coming thereafter. You had the case of Hussain Ara Khatun coming thereafter. You had the case of Sunil Batra coming thereafter. You had the Ratlam municipality coming thereafter. You had the case of Ajmal Kasab coming thereafter. You had the case of Muhammad Hussain coming before the Supreme Court, where the court talked about access to justice. Court talked about Lalita Kumari registration of an FIR, and it talked about access to justice, fair trial, speedy trial as essential component of Article 21. Now, we need that kind of an approach in the Supreme Court now, and judges have to revitalize themselves. They have to regain that legitimacy. They have
You are confident that some solution and way out would emerge from the judiciary itself? Are you suggesting that?
I think what is important is all the stakeholders in the justice administration have to put their heads together, and we must collaborate in that process and find how we can have a robust judiciary in this country committed to constitutional morality and fundamentals of the Indian Constitution.
Thank you very much. You have brought it out in a very lucid manner, and that makes sense. And let's hope that the various stakeholders which you have pointed out would pay heed to it and some new light would emerge. Thank you very much.
Thank you very much.